The case of Dr Hadiza Bawa-Garba has rocked all of us as doctors.
No doctor should be scared that an honest mistake will see them thrown in prison and their career ruined.
No patient or family should be worried that when mistakes do happen, that they'll be faced with years of opaque investigations.
This is a watershed case. We are a group of doctors who are determined to stand up for patient safety. The Norman Review into Gross Negligence Manslaughter gives us the ideal opportunity to make our voices heard.
We will be campaigning so that the law on gross negligence manslaughter is urgently reformed. No doctor should be criminalised for doing their absolute best under increasingly deteriorating systemic conditions that have been imposed on us.
There must be a higher bar set by the Crown Prosecution Service to consider pursuing a case of manslaughter against doctors. Doctors cannot do their jobs properly if the threat of being thrown in jail for making a simple mistake results in criminal prosecution or impacts our clinical decision making. Learn, not blame.
There must be an independent investigations body whose first priority will be to explore the systemic failures that always surround medical error. When there is a plane crash, a thorough independent investigation takes place that examines every detail of the chain of events that led up to the crash. Why don't we have this in healthcare? A thorough independent investigation would not allow a trust to throw a junior doctor under the bus whilst not learning from their own mistakes. Learn, not blame.
We need written reflections to be protected by law. We've reached the unprecedented situation where doctors feel too nervous to write things down on paper when things go wrong. We need a safe space to debrief so that we can improve things next time. We owe this to our patients. We need to learn, not blame. We need to repeal the section of the Medical Act that allows the GMC to compel doctors and their royal colleges to release and disclose our information written in written reflections when we're in court. It's not enough that the GMC have provided verbal assurances that they're not going to use this information. We need this enshrined in law. We need to learn, not blame.
We must repeal Section 40A of the Medical Act, which gives the General Medical Council the ability to appeal medical practitioner tribunal verdicts. The courts have established that it is the professional tribunal and not the High Court that is best placed to judge on the competence of doctors. They have the necessary expertise to unpick complex medical decisions and to understand the pressures that we often have to work under. Their decisions should be final, and their focus should be first to learn and not to blame.
We must have assurance from the Department of Health that they will not give the GMC the powers to automatically erase doctors off the medical register. Every doctor deserves a fair hearing, and the GMC must not be allowed to deny doctors, patients, families the opportunity of a tribunal to explore the systemic failures that surround medical errors and harm. Learn, not blame.
We will be
Submitting our own evidence to the Norman Review.
And encouraging you to do the same.
We will be working with the grassroots and the unions.
Lobbying the royal colleges.
And working with the Medical Protection Society.
We will be speaking out on patient safety issues, rota gaps, underfunding, overcrowding, physician fatigue, chronic IT failures, and the desperate need for safe staffing ratios to increase patient safety.
We'll be campaigning for more open and transparent investigations in the NHS for patients and their families.
We will be launching a public campaign, My Honest Mistake, to highlight that doctors are human and that under extreme pressure we can make mistakes.
We must, as a profession, do better to learn. We owe it to each other, we owe it to our patients, and we owe it to their families.
We can do better. Learn, not blame.